That brought a lot of people in fast. Well, good morning, everyone. We've got quite a crowd coming in this morning. We're looking forward to it. Should be a great program. And let's just give it a couple of minutes here for a few more to trickle in, and then we'll get to work. Are there more in the waiting room, Allison, or hard to tell? You're muted.
That she's letting him in right now.
Okay.
All right, everybody's in that's currently in the waiting room. So,
all right, well, let's go ahead and get started. We had 143 signed up for today, so I bet you some more will be joining us, but we are delighted to have you here. This is going to be an exciting Zoom call. And boy, as of Friday, we thought, I mean, we knew there were some important things, but we didn't know it was going to get so crazy. The Supreme Court has actually released more information this morning that Jim's going to update us on. And there's enough on our agenda that we think we may have a second meeting on July 5th because there's just a lot of stuff to cover. So let's get on with it. We've got some great guests here for you today because there's some new things happening. And so I'll go through these in just a minute, but Jim is back and he's going to share some stuff. And even Tyler's going to come in at the end and he's got some things to share. We also have a very special guest named Jason Rotherman. And I'll give you his full bio in a minute, but he's going to be talking about active shooter and other things that are, you know, kind of gun threats in the workplace. And we've got Lisa Gabbard, who is a real leader with the Kentucky Coalition Against Domestic Violence. And she's going to talk about how to recognize those kind of challenges at work and what that means for us. Of course, Allison and Chase and Kendra are all on here to help us out and to move through today's slides. So let's slip to the next slide and we'll move right along here. Kind of 5 things we're going to cover. Workplace violence, we're going to start out with that, and some great statistics or not so great statistics. You're going to be surprised at how that's growing right now. It's terrible. We're going to talk about recognizing and addressing domestic violence in the workplace because these two kind of go hand in hand. We knew we'd have some things on COVID, but we didn't know how impactful the whole Roe Wade thing was going to be and how that messes with your insurance. You guys are going to be surprised about that, but you're going to have to know more about that coming down the pike. And then we're going to wrap up with other legal and regulatory changes that have just, you know, they're hitting us right now. So guess what? HR continues to be the most important organization in the building. A lot going on, but we're going to try to keep you up on it. Boy, don't just hesitate for a minute to raise your hand or put some things in the chat because we want to make sure we're responsive to what your needs are. Let me just give you a quick introduction of Jason because he's terrific. He just retired as Special Operations Sergeant with the Lexington Police Department. Listen, I went all over the state trying to find out who knows the most about this stuff, and it brought me right back to Lexington and Jason. He's had just a ton of recognition during his career, oversees strategic operations of both public and private sector for organizations, strategic law enforcement operations, legislative creation. He's an active lobbyist and does a lot of things in the private sector initiatives in helping keep workplaces as safe. So just a couple of other fun notes about him. He's earned 5 commander letters of commendation, 3 professional service awards, 2 unit citations, 14 letters of appreciation. He's nominated for the Supervisor of the Year in 2020. Just the awards go on and on. He's been the head of the Fraternal Order of Police in Central Kentucky and has gotten their Officer of the Year award. So, Jason, with all that said, I bet you've got some things to share with us. You take it away and tell us what we need to learn about, you know, all the new changes and the gun threats and challenges we're facing.
Sure. Well, thank you for the kind introduction, Lyle, and I'm very happy to be here. We got here, like Lyle said, through a roundabout way of mutual connections. But I think we have a pretty pertinent topic given everything going on today. So this is really going to be a really 40,000 foot view of what's going on. There's obviously, as somebody who talks about this stuff on a weekly basis with corporations and organizations, we could go for 8 hours and I'd not be tired, but I don't think anybody wants to miss lunch for that. So you'll see as we progress, we'll just go into the overview of what we're going to talk about. And generally when I do these, I end up getting a lot of questions. So towards the end, I'll kind of move through this. And if you all do have questions, I know Lyle and them say that you guys will put some in the chat and they'll bring those to my attention and I'll try to address those. But we'll talk about what is an active shooter, the actual definition. You hear it. I mean, you probably know in your mind what it is, but just so everybody's on the same page, we'll talk about what the FBI and the Department of Homeland Security, what all of them classify as an active shooter, what qualifies as a mass shooting event. A lot of people, when I break that down, you'll understand, I think, some of the statistics that you may see on television or stuff. You may understand that a little better. Why is all that important to us and to you? And then we'll go over just some considerations for companies and organizations and people in your positions. So if that sounds good, we'll just breeze right on through it. So as we said, an active shooter, what is an active shooter? Well, according to the FBI, the active shooter is classified as one or more individuals that is actively engaged in the killing or attempting to kill people in a confined and a populated area. So it's a very broad definition, pretty much what you think it is. In terms of a mass shooting, which I tend to hear mass shooting more than the active shooter, because mass shootings are just, sometimes there's multiple suspects and the scenarios are unknown, but we know what the event is. And if you look at websites like the Gun Violence Archive, it's an event, and the FBI even qualifies it when they look at their stats. It's an event in which 4 or more people, not including the suspects and the shooters, are injured or killed. So sometimes when you see X amount of mass shootings, and we'll talk about this a little bit, you will see statistics that seem very, very high, very regular. And those are lumped into, we tend to have an idea of an active shooter as somebody on a mission, somebody who is going into a business or a church or a school. It's not always the case. It can be a gang incident that is totally unrelated to commerce, totally unrelated to your business. 4 people get shot. That's considered a mass shooting from a statistic standpoint. If you look at places like the Gun Violence Archive, I put this on here because I think it's been on every news broadcast. Many of you probably heard about it. This is the reference point for a lot of stats. And if you look at where we are now in 2022, just tracking the incidents, we're at 250 mass shootings plus, and we're just going into July. Now, if you look back at the mass shootings by the year, these go back to the FBI statistics, and what they do is they go back throughout the year, make sure that the classifications match, and then they put out these numbers. So in 2021, we had 61 mass shootings. 2020, you see 40. 2019, you see 30. In 18, you see 30. In 2017, you see 31. So not great statistics. I know Lyle mentioned it's not always a fun topic, but it's extremely important to understand where we've come from, what kind of the norm is, and the means and averages, and what track we're on now, which directly correlates to the next slides, where we talk about what this means for us, what this means in terms of preparing for incidents.
So, 250 and a half a year compared to those other numbers.
Yes, it's staggering. I don't even want to know what the percentage of increase is going to be at the end of the year, but you can see, according to the FBI, from the year 2020 to 2021, we saw a 52.5% increase in active shooter events. If you go from 2017 to 2021, we have a 96.8% increase. The casualty rate rose from 164 in 2020 to 243 in 2021. The reason I bring up that statistic is because there are instances in these active shooter events, and we'll talk about it a little bit in preparation. There are risk mitigation strategies for events like this that we can include in our emergency action plans, like gunshot trauma kits and things of that nature. And those preparation items have been used to mitigate the casualty rate in active shooting. So that could be a lot higher, I'm sure, from year to year, but there has been some lives saved because of preparation. So really interesting stat that I found is that according to the FBI in 2021, areas of commerce were the most targeted locations. So think about that and wrap your head around that, and not knowing everybody's business and what they're doing. But how many of you all are either located in, near, or frequent areas of commerce? And that's anywhere basically business is done, anywhere that people are exchanging money for goods and services. So that for me, to see the FBI actually narrow that down, that was eye-opening for me. A lot of times, because we get a lot of calls. Over the years, I've helped churches, nonprofit organizations, and those and schools, right? We get the schools and churches get a lot of media attention, rightfully so. But when you look at the numbers and you look at the most frequently targeted areas, really put this conversation in context for me. So that really leads me into just kind of, again, giving this high level view of some things that we need to think about, people in your position, the considerations that you have. Some of you guys on this call have probably done an extremely good job already. You probably already have an emergency action plan. Maybe you've done workplace violence drills. Maybe you have trainings that you do regularly. And I would almost guarantee that there's some people on this call that are on the opposite end of the spectrum. They don't have an emergency action plan. They don't discuss what the obligations are from an HR standpoint in OSHA. They don't do regular training. So hopefully this talk, if you're in that category, hopefully this discussion prompts you to do so. I put OSHA on here. I know that's kind of your all's jam. But when I started working with companies and organizations, I found that this was kind of a big deal in terms of providing workplace safety and the duty to do so. They don't necessarily regulate kind of how you do the workplace violence stuff. I'm sure that's probably fluid at the moment, but you all understand things such as the general duty clause and the intricacies of OSHA and providing a safe workplace all around. So clearly, if this is a known hazard, which it's been identified as a known hazard in various ways, it's something we need to consider. Along with that, that's the federal government regulations, but I want to talk about, with all these stats, with this being such a prevalent issue, we want to look at the internal policies that you have. I talked about everybody that either has or doesn't have an action plan. They either do or don't practice. I would ask each and every one of you to ask yourself, what are our internal policies that help prevent these types of events? And I do want to point out, you'll see down, if you go down a couple bullet points here, I'll skip one, but you see the term active aggressor. And when I use the difference between active aggressor and active shooter, when I've talked to corporations and organizations, so many people focus on the gun violence aspect, but I know there's Lisa with the domestic violence here, domestic violence assaults and other types of weapons such as knives, any other type of weapon, that is an active aggressor scenario. And many of the precautions that are taking place to prevent an active shooter will play out to help protect staff from an active aggressor. Does that make sense? So when we look at internal policies, we want to look at things like our visitor policies. How are we allowing people into the building? How are we tracking their movements? A lot of times I would have clients, and because they know me, I mean, we've put
Then you think about the compelled to do the part, do the Ernie route. And then if you have more gas left in the tank, do the Iron Bridge route and add on at the end.
Can you go ahead and mute that person?
Sounds like somebody's running out of gas.
Yeah, sorry about that.
No, you're perfectly fine. But as we move through this and talk about our internal policies and how our visitor policies allow access to the buildings, how we track people and where they're allowed to go within the building, is going to be a big deal. And it's going to allow us to restrict access to people that we don't want in there. What I was saying is, I have some clients and have had clients that I've worked with over the years that put up bulletproof glass, visitor policies, all this kind of stuff. They recognize me, I wave, I walk in, and I end up asking them, say, hey, you know me, and you just let me in. I didn't do any visitor protocols or anything. Is that normal for people that you know, like your husband or her boyfriend or his wife? A lot of times the answer is, well, yeah, we know them, but we normally don't have any idea what's going on in that person's home, outside of work. So I see people that put a lot of work into visitation policies, visitor policies, and they kind of circumvent those. When we talk about technologies, there are mass communication technologies out there. How do you notify your staff in an active shooter or active aggressor event? Those types of things all play into what is the most important and most critical thing in preparing and surviving an active shooter or active aggressor scenario. That is training. And I know how difficult it can be to get everyone on the same page. But again, training is by far the most important thing when it comes to survival. I put on here run, hide, fight, because that is the basic guideline of the federal government. It's been around for a long time. There are some additions to it. People do some variations of it. But I wanted to bring up one point. Most people have memorized or seen run, hide, fight. I want people to understand that that does not mean you run first, you hide second, and then you fight. These are not in an order of preference or probability. These are things that you need to understand. If an active aggressor is in your face and is actively trying to harm you, you may have to fight for your life first. Then you might have to run. Then you may have to find a place where you can lock down and hide. So I want everybody to understand that while run, hide, fight, it's basic, it's survival. It doesn't have to come in that order. Trainings. I know a lot of people I've assisted with online trainings throughout the year. They work them into their HR management software. They throw a 20-minute module in there annually for their people. And then we go as far as doing the in-person trainings, the active shooter scenarios. And I want to stress, it's not always about shock and awe. People don't, there's a lot of companies, there's a lot of individuals that would come in and fire off gunshots and do all this kind of stuff and try to freak people out. I've never found that to be, while people enjoy the drama of it, we want to provide an adult learning environment for people to retain this very important information. So it's always something that I point out, because we do have a duty to create a safe workplace, even when we're training about a non-safe workplace at the time. Include relevant technologies, your camera, your access control. If you have mass communication technologies, all those things should be incorporated in your trainings so that people are used to the alerts, so that they know how to use the technology that could potentially identify an active shooter, help save their life, locate them. We want to make sure that if we're paying for these as companies, which a lot of people do, that they understand how to use them. Again, by far, the most important key to survival for you and your staff is training. It's how law enforcement prepares for it. It's how the federal government prepares for it. But we need to put our mind into that survival mindset, and muscle memory goes back to what we've taught ourselves. So that's why that's on there. Hopefully this has all made sense. If we can move to the next slide. I tend to talk fast sometimes.
That's good. Keep rolling. You're doing great.
Prevention and preparation. We talked about training being the most important. The prevention and preparation aspects of this, these are questions that I ask companies and organizations when we're talking about what their plan looks like. And there's a lot of resources out there that would help you create an emergency action plan. The Department of Homeland Security puts out an active shooter workbook, and I will put that in a link for Lyle after this so that he can send out after this conversation. But it's a really good resource guide if people don't have the resources to have somebody come in and do threat assessments and stuff. But does your company have an emergency action plan? That's something everybody on this call should ask. If the answer is yes, then that's fantastic. Do you have mass notification technologies? I know many school districts, there's a lot of options out there. It's actually a pretty competitive space. And it's a good tool to have. But again, like we talked about before, it's only if people know how to use it. If technology is confusing, then they're not going to be able to use it, especially when stuff hits the fan. Gunshot trauma kits, another highly competitive market, but there's been numerous stories on the news about how these tourniquet kits have saved lives. People that have been shot and injured were able to access, or someone else was able to access one of these gunshot trauma kits or a first aid kit with a tourniquet, apply the tourniquet, and that person lived. That would have been another casualty number that we saw. So another great investment. And last on here, have you had a threat assessment? Most people don't understand what a true threat assessment is, how extensive it can be, and the importance of it, because it allows a third party to identify objectively your weak points as an organization. And those can be policies. Those can be training procedures. All of those things. Do you have mass notification? What's your visitation policy? All those things play into a threat assessment, a true threat assessment that show you where you can improve on. Hot topic right here. What to expect. Everybody's seen the news. I won't go down that rabbit hole. It's a tough spot for our country, for schools, for organizations. What is it going to look like, and what's that response going to look like? First off, we tell everyone it's going to be absolutely it's chaos. That is the intent of the shooters. That is the intent of the aggressors, is to create chaos and death. And so we have to just look that in the face and call it for what it is. You saw in many of the recent shootings like Uvalde, various agencies, state, federal, and local, responded with all different kinds of uniforms, some off duty, some on. So I want you all to understand that the law enforcement response could be a school resource officer in a uniform and a police officer from a different jurisdiction, or a state trooper. All of those people could actually be responding at the same time. And when they respond, it's going to be, they're probably going to shout commands and all different kinds of things. So just understand the chaotic moment that you are in and that they are responding to. And this is the hot button topic. And I don't put this on here to be controversial, but I want you guys to understand, and this is something that I've taught for years. Law enforcement's goal is to stop the threat. I put this on here knowing the controversy that's out there, but I put this on here because I want you to understand that when you train, when you prepare in this scenario, their goal, and when I trained for tactical entries to go in and address an active shooter, my goal and our goal as a team was to stop the threat. And that sometimes means bypassing people that need aid. And so you need to understand that when you train, when you prepare with gunshot trauma kits and things of that nature, it is about you taking survival into your own hands if need be, and knowing how to do that so that law enforcement can go stop that threat and you're alive to see the successful ending of that. Big point of conversation, but I want everybody to understand that you know, that is the main goal in active shooter training for them. And so they're going to be moving quickly through the building, or they should be, to address an active threat. I'll leave it at this. Something my dad taught me a long time ago. Usually when I didn't study for a test and I was trying to throw excuses as to why I didn't do well, my dad would always say failure to plan is simply planning to fail. And that's true in life. And it's definitely true when it comes to your survival or the survival of your staff. So I know that's a really brief overview. I hope that there were some nuggets of information in there that you guys find useful. And with that, I'll yield it back to Lyle.
Wow, thank you very much, Jason. A lot to consider. And I haven't seen anything pop up in the chat box, but that doesn't mean they won't come along. So if you can hang with us, I hope you will.
There is one, Lyle, there is one in there. One person asked if Jason could provide companies or who can do a threat assessment for us. So there was a question about whether he has services available to assist with this. And there's a couple other questions
Sure.
I'll pop in or I'll throw in there here in a second.
Sure, I'd be happy. That's one thing that I was going to provide Lyle as a follow-up. I will ensure my contact information is out there, and I can help connect anybody with services if they need a threat assessment or any type of active shooter training. I see here on the chat Lexington Police Department does provide. Most PDs try to provide some type of active shooter training. The interesting thing is there's a lot of people out there that try to provide it because they see a market for it. And they also, the reason there's a market for it is because police staffing numbers, this is one of the first programs to go in community services, is because police simply don't have the staffing numbers to staff a beat on the street. So the programs, there's usually a long wait for that.
Well, I spoke too soon because the questions are rolling in now. Go ahead and just take a look down those if you want to.
I'll read them for him.
Go for it.
Sure.
All right.
Yeah. So one did say Lexington Police, a school said KSP, but I think that's a different scenario for schools because of the role that KSP would have. Question was asked, what is the best way for HR leadership to encourage employees to share their domestic violence, real or potential concerns, so we can help them better? And that may come in for the next speaker. But if you have any input on that, that would be good too. I don't know if you have input on the HR side or not, Jason. I'm not trying to put you on the spot.
Here's what I would say. Lisa's probably a better person to go into detail about that with experience. But what I will say is, we talked about reporting mechanisms in preparation, ensuring that people have confidence in the reporting mechanism, and ensuring that the information, if somebody does come to you, we saw in Parkland where there was information given to the FBI, there's information given to the sheriff's department, and it was not communicated prior to the shooting with each other. So the flow of information and ensuring that your reporting mechanisms get to the right place, that those indicators, early indicators of a potential incident are noticed, is extremely important.
So maybe we'll have a follow-up once we get into the next, but it rolls very nicely. But there is another comment or question, and I think this is a very relevant one. What method does a company take to calculate how many gunshot trauma kits to have on hand? Is it by head count, or what would you recommend?
So honestly, it can be dependent upon the facility, upon your layout. Generally, if you're going to put the resources in to purchase those kits, if I was working with a company, we would tie that directly into the threat assessment and say, here's where we want these gunshot trauma kits. Here's where they should be. The general number is 10 for about every 100. And having those strategically placed. I mean, you can never necessarily have too many, obviously, in a bad event, but that's just kind of a general rule of thumb. And then making sure those are strategically placed throughout your facility, accessible, people know where they are is very important.
So those are the comments that we have so far. I'd encourage you to stay on because chances are they'll pop up again when we get to our discussion about policies and procedures that impact liability and so on. And also after the domestic violence. So if you can hang on, I think that'd be really good.
Great.
Yeah. Well, thank you very much for the opportunity.
You bet. And if you want to, if you dare, put your contact down there in the chat under everyone.
Sure. Sure, I will.
I don't know if you want to do that, but otherwise we'll get it out to people that ask about it, certainly.
All right.
Well, we've got the next guest is Lisa Gabbard. And Lisa has a terrific background too in leadership and training prevention for Kentucky Coalition Against Domestic Violence. She's a East EKU and a Georgetown College grad, undergrad from EKU and a master's from Georgetown College. She taught in the public schools for 18 years, so she's faced the front line in a lot of ways. She's been with the coalition for almost 14 years and does a lot of work in their leadership and training and prevention work for domestic violence that spills over into the workplace. So Lisa, we are delighted to have you here. Take it away and tell us what you want to share, and we'll watch your chat box for questions too.
Great. Thank you, Lyle. So nice to be here. I appreciate the invitation. If I had only known that Jason was going to share all his great accolades, I would have thrown some of mine in, but appreciate the work you do, Jason. That's tough. And I know teachers really appreciate law enforcement. As you say, it's a kind of a current issue, unfortunately, right now. So yes, I was an elementary school teacher and, decided I was making too much money. So I moved to nonprofit work. But KCADV is a great place to work. We are considered a quasi-governmental nonprofit. So we have, we're in the state retirement and insurance systems and whatnot, and have similar holidays and that sort of thing. So I think a lot of folks, when they think about, wondering if an employee or a colleague is a victim of domestic violence, it may come to mind that you need to tell somebody about that. Oh, well, I think my colleague is being abused by their partner or their spouse, and maybe I should get them some help. As you see, if you would there, I think it's Jim controlling the slides there on the next slide. That's not a requirement legally any longer. And that used to be in Kentucky. Any person who believed or had reason to believe that someone was a victim of spouse abuse, they called it, not even intimate partner violence or partner violence, but spouse abuse, was required by law to report that either to CHFS or your sheriff or a court official or what have you. That was changed in 2017 to mandatory education and referral. And even though it's called mandatory, in reality, the group of people for whom it is mandatory is not everybody the way it used to be. Now, this does not change at all the requirement for folks to report child abuse, suspected child abuse, elder abuse, or abuse of a vulnerable adult. Those are still requirements. But as far as domestic violence, what we prefer now is for folks to educate and refer people to where they can get help. And if you wonder why, well, why not let CHFS know if this family is in danger? What we learned when we were doing some research in our efforts to get the law changed is that a lot of people don't want that made public. And not that CHFS is public per se, but it may be more dangerous, for a victim if they're living with their perpetrator. The perpetrator says, hey, we got a call from CHFS. The neighbors reported me for beating you up or something, and so we found that was not a safe avenue for a lot of victims. So we, again, have gone to this mandatory education and referral. What we would hope that you could do if you thought, again, that a colleague or employee was a victim is that you could provide them information about the domestic violence program that serves where you live. And we'll get into that on the next slide in just a moment. But that way folks can decide, do they want to reach out? Is it safe to call a domestic violence program? Do I need help? Or, they can decide when and if they want to do that. And I did include a little bullet on here to please, if someone asks you to report, that's different. But don't just say, well, I saw so-and-so with a bruise and I bet their partner beats them up. I'm going to, call the sheriff's office or whatever. Please don't do that. That may not be safe for the person. And it is still legally required for a professional in certain positions to provide that information, depending on where you folks are. And I apologize that I don't know where all we've got people here from, but for a lot of people, that's just a recommendation or it's something we hope you would do. But for certain professionals, it is considered the law, and that would be any kind of medical personnel. That includes doctors and nurses and school nurses and things like that, school and childcare personnel. So not just teachers, but anybody who comes into contact with someone in a school setting, a minister or an ordained equivalent. And I know when this law was going into effect, we had a meeting at KCADV with some clerical folks, or clerical isn't the right word, but religious folks. I was thinking of the man wearing his clerical collar. The religious folks wanted to know, hey, what is our requirement? And they really are, not obviously if you're sitting next to somebody at a softball game and you think they might have a bruise, you don't need to whip out a pamphlet. But if they, were to come to you, you should provide them with that information. And if that is your job, any kind of victim advocate, whether you're a court advocate, you work at a domestic violence shelter, rape crisis center, what have you. And then this is a big umbrella, any agency employing any such professional. So that leaves a big group of folks who are either required or their organization would be required to provide mandatory education and referral. And that, again, that referral would be to a shelter program that could help someone depending on where they live. And now in Kentucky, as you all know, we have 120 counties. Yay. It's a little overwhelming, but what we have done in our state is set up area development districts for the provision of services such as domestic violence and rape crisis help. And I have a map, which I did not include here, but is in a packet of information I provided to Allison that she will share with you all to show what county is served by which shelter. But it doesn't require a person to go there. You can call and have help over the phone. You can do Zoom meetings. They have outreach folks who come into all the counties. So if I'm in Franklin County, for example, the shelter that serves Franklin, where I live, is in Fayette County. But they have outreach folks who, if I needed someone to go to court with me about a custody issue or a domestic violence issue, they have those people. And as you can see there with that list of services, they will do that. They will help with case management, safety planning, especially if someone chooses to stay with an abuser, because as you may have heard, it's kind of a well-known statistic. It takes a person 7 to 10 tries to leave an abuser. So they may be there for a while. And so how can they stay there safely with that person? How can they be safe when they're leaving? Support groups and individual counseling. And again, those can be in person and virtual. Housing assistance. So if someone is ready to leave, can we get them a voucher? Can we help them find safe housing? Can we help them pay for rental and utilities and things like that? Job search assistance. And that can be anything from helping them look for a job, helping them apply, helping them with a resume, giving them appropriate clothing for an interview. And then the flex funding, that kind of goes back to the housing assistance. If someone has a place to live and the only thing stopping them from moving out into safe housing is a broken down car, we can help them get car repairs so that they're then able to move out if that's what they wish to do. Another great thing about the shelter system is that they do serve everybody. So if someone is a victim of domestic violence, they will receive services. It doesn't matter the person's gender or their sexual orientation or where they live or if they have any money, their marital status, their citizenship status, nothing, that does not matter. We provide services to people who need them. So I just like to make sure and get that message out there, because sometimes people think, well, I'm in a same-sex couple, or, well, my American citizen husband is abusive, but I'm not a legal citizen at the moment or whatever. So we do help anybody who is a victim of domestic violence. So that's a great thing about our programs. Something to think about when you are considering talking to somebody in your workplace that you think may be a victim is that if you ask them about it and they don't want to talk about it, you really need to respect that. And so at the last bullet, these are probably not in the best of order there, but the last bullet says follow the lead of the person. If they don't want to talk about it, then that's fair. And if they do, then you need to believe them. And I know sometimes that's difficult. People tell you things that may sound outrageous, or they may tell you something one week and tell you something different the next. And of course, we're starting to learn in the last 10 or 15 years about the effects of trauma on the brain. So folks aren't necessarily lying. They're remembering details. They're maybe scared to reveal some things. So it's really important to let the person take the lead with how much they want to share, if they even want to admit to being a victim. And then it's important for you to believe that person when they share those things with you. There was a question earlier, and you all said we would get to this. And so I thought this would be a good spot to bring that up about potential problems. And I assume the lady who posted the question was referring to just say, for example, I work in an office and my partner is abusive. Do I need to tell my colleagues that he may show up or she may show up at our workplace and be violent? You know, you might think that that's my responsibility, but there are some people, again, who are afraid to do that because perhaps the person walks in and then someone says, hey, you're not allowed to be in here. That triggers the person to realize, oh, well, my wife is obviously telling people that I'm dangerous. And so that may not be safe. So again, it kind of just depends on what an individual feels safe sharing. That one bullet there that I haven't addressed, consider keeping a log of what you see or hear. In the resource materials that Allison will share with you that I compiled, there's a link to a video, and it's from a Diane Sawyer 2020 interview, and it'll look a little dated. I think it's about 20 years old, but it's a really good example of someone who was suffering domestic violence at home, a woman experiencing violence from her husband, and her colleagues were concerned. One in particular would make note of that the woman came in on a given day with a bruise, or she came in on a given day with her arm in a sling, or she called in, or she came in late, or maybe this colleague heard strange phone conversations going on between this woman and her husband. And so she just kept little notes in her journal or like in a calendar. And when the woman did finally escape and decide to press charges against this person, this woman's log was really beneficial because it kept it sort of from being a he said, she said thing. And this woman could say, well, I'm her supervisor and she was late to work these days and bruised these days and had strange conversations. And I heard him on the phone tell her, you know, that he would beat her up if she didn't get home in 15 minutes or what have you. So that's something to consider, you know, again, depending on what you see and what level of conversation you are able to have with someone in the workplace. Let's see, I think I had a feeling when I was approached about this that probably what a lot of people were looking for were warning signs. And I've already mentioned the bruises and the odd phone calls and calling in and maybe even someone showing up at your job. Unfortunately, you know, you may not see any of those. So on the next slide, which we can look at here in just a moment, and also in your resources, you will see something that we call the power and control wheel. And by we, I mean folks in the domestic violence movement. There are multiple versions, but there's sort of a generic version that is presented from the standpoint of male-female partnership, where a male is a perpetrator and a female is a victim. And of course, we recognize that that isn't always the case, although in 85% of situations, approximately, that is the case. But what the thing to know is if someone is experiencing the things on this wheel, that person is a victim. And if someone is doing those things to other people, that person is a perpetrator. Now, there are instances where a person can be a perpetrator and a victim at the same time, of course, but there's generally a primary perpetrator and a primary victim in most cases. And what we find, and what we have found over the years, is that victims who use violence in return are doing it, you know, because they're in fear for their lives, or it's the only way they know to fight back, or it's what they've, you know, seen in their own homes as children growing up or whatever. But in reality, there will be one person who's the primary aggressor. So if we can look at that power and control wheel for just a minute, you'll see, I realize it's kind of small, which again is why I didn't put our state map on here because it would have been so little. But generally, a perpetrator will use some of the threats and intimidation type things in the pie slices there, I guess you could say, in order to kind of keep this balance of power over a victim. And sometimes many of these things will be happening and there is no actual physical or sexual violence. So a person thinks, well, I'm not a victim. You know, I knew somebody who got beat up all the time. I'm never getting beaten up. But if you look at these things, you know, if someone's intimidating you and coming to your workplace and or calling your workplace and getting you fired or ruining your credit or saying, well, you know, you're not a US citizen, so I'll just take our kids and you'll be deported, or any number of those kind of things where somebody can use some sort of threat over somebody, that we consider that power and control, and we consider that to be domestic violence. Now, in the state of Kentucky, actual physical violence is considered domestic violence, but so is the threat of it. Unfortunately, of course, we know that folks don't, or I should say rarely would anybody be prosecuted for the threat of it, but you can imagine how, you know, horrible it is to live your life under the threat of potential violence if you're not doing the right thing, whatever that might be this week or this afternoon or whatever, because, you know, perpetrators will change their tactics. You know, this week it's okay to hug and kiss your kids as they get on the school bus, and next week it's not okay. So, you know, we know those kinds of intimidations happen. So this is kind of an interesting wheel, as I say, written from sort of a heterosexual female victim, male perpetrator point of view. There's a website, and I'm not sure it's visible on this wheel because I cut it to make it larger. I cut it down. Yeah, right there. Okay, so the Duluth model, they include many wheels on there, and some of those I've actually included in the packet of resources as well. So there's information about African Americans, there's information about same-sex couples, there's all sorts of things there at that Duluth model website. So hopefully, I see someone made a comment that it's eye-opening. It really is. And, you know, I think of myself as a huge animal lover. And I think, boy, if somebody said to me, you know, if you move out, I'll just kill your cats. Well, I'm not going anywhere. You know, if I can't take my cats, I don't want to move out. Luckily, a lot of our shelter programs have started having ways that folks can bring their pets as well, and children, of course. So at any rate, those are all, again, very things that you may not see as you work with someone, but may be happening to them behind the scenes. So again, in the resource packet, there's several links to a couple videos and some other things, but I did want to just include this here. Feel free at any point to reach out to KCADV. We have a website, which I've put there, where you can see a map, which, as I say, is in the packet of resources, but it is also available online. We also operate the Batterer Intervention Provider Program through KCADV. So we're also working with folks who are perpetrators. Never at the same time, but we run that program for the certified folks who do offer those courses for people who are court ordered to go through them. And then there's my contact information and our general phone number, and we have a staff attorney as well. So if you ever felt like you needed some legal advice about domestic violence, we would love to chat with you. You're welcome to peruse our website, and it has links, as I say, and the map to our shelter programs, and all of our shelter programs have their own websites as well, and talk about services that they provide. And unless there's anything specific, I see a few things in the chat. Looks like folks sharing, Jim sharing my information and that. And yes, Rebecca.
Yeah, I hope you're okay with that. I just, when we moved slides, and I accidentally clicked the slide when I thought I was typing, but I wanted to make sure your information was shared. That's all.
I appreciate that. Yeah, like I say, it's here, it's in the chat, and it's also in the resource packet. So happy to talk to anybody or put you in touch with the right person if it's not me. So if anybody has any issues or concerns, we would love to chat with you. Thanks.
Wow, Lisa.
Well, I want to make one comment,
Okay.
which I think is covered on Tyler's, because we didn't know that this was going to be covered, so I don't think he had it in there. You have to be really careful. She mentioned about, you know, mentioning to somebody, hey, be careful because John or Jane may be coming by and there might be an issue with that person being violent. You have to be very careful as an employer allowing that kind of discussion unless you're absolutely certain, because that person could sue you for defamation because you're out there telling people that John Smith or Jane Doe are verbally or physically abusive. But as an HR person, you have to make sure that you have proper control over the sharing of information, because you don't know what's true and what's not. And you have to be very careful not to do too much and jeopardize yourself. Liability is constantly an issue, and you could get sued by the abuser if you can't yourself prove that they're an abuser. Sorry, I'm just the bearer of bad news, but I have to cover some of that.
That makes so much sense. And I'm glad you mentioned it. And it goes back to, you know, what Jason was saying about training and having a plan and having, you know, a visitor protocol and that sort of thing. So that makes perfect sense. So that doesn't have to be discussed.
So
And-
communication and education make a difference.
Absolutely. And I see Scott's question there. If you can go to our website, I believe there's and I should have apologized, kcadv.org. Yeah, pretty simple website. But if you can look there, I'm pretty sure we have handouts on there that can be printed out. I wish I thought to include it in the resource packet, but I don't think I did. And yeah, that's something that you can just have. You know, we talked again, like I said, to some clergy who came to our office and whatnot about, you know, this is something you could fold up and have in your pocket or whatever. So yeah, Rebecca, it really, yeah, it's a fine line, isn't it? So I'm happy again.
Yeah, wait, I smiled too because Tyler's getting ready to talk about that fine line when he gets up to talk about these policies and procedures, because it is a tremendous fine line with the general duty to protect under OSHA, the duty in general to train and make sure your employees are competent and capable, and then you have it makes it really difficult. You've got a duty to protect that you can't go out and say, because if you do, you might get sued from the person that you said, hey, I think this guy's a danger to the rest of our employees. Welcome to HR, like Lyle said. And by the way, Lyle, as you introduced me, let me just tell people, if you know someone who's not on here who usually is, you might want to send an email because or a text. This is probably going to be from here on out, including what they should have already seen. This is one of the most important ones we've ever done because of the updates I'm about to share with you. It's one of the reasons why we're going to do this next week too. So go ahead, Lyle. Yeah. Sorry to
Jim needs a little introduction. And Jim, it's terrific to have you on here. And we've been discussing this over the weekend and today, this morning. Things are popping like crazy. And I know you and Tyler both have a lot to cover. So let's jump right in and take it away. Those of you that don't know Jim, you need to know Jim. He's awesome.
All right, so I'm going to cover something right now. You've seen this map for 54 different times. Actually, we took it off a couple of times. This was more red last week, and I've shared with a few different companies the concern I have about what we're doing with our COVID reporting. So I wanted to share with you this. You see the red, you see the orange, you see the green. Most of it was red last week. I'm done with this map. And I want to tell you why. Not a political statement, just reality. We had testing centers open throughout the state, and people got tested before they'd go see their Aunt Jane, their grandma, their grandpa, their parents, their children, their grandchildren. People were being tested nonstop. We had drive-through testing everywhere, available all the time. Everybody stopped doing that. So now the reason why what they do with their community level is they test the, quote, percentage of positivity rate. The problem with testing the percentage of positivity rate, if you don't have very many people testing, the positivity rate goes up. Common sense. Well, if you shut down all the drive-through and all of the things, it's now difficult to find a place to go. You can't drive through anymore. You have to go in. Hospitals still do it. Some big centers still do it. But the reality is we are no longer testing like we were. We need to have a straight number per 100,000 and not the positivity rate being the percentage of testing of people who tested positive in the tests that were given. That's the concern that I have. We ought to just go with the straight population. And then when you see that I'm making up a number, 0.1% of the population or 10% of the population, then you have something to get concerned about. But they're still going with the red county requirements of no in-school, shut down your businesses. Nobody's following it. So it's time to stop. So I brought that in just so you understand, because a lot of people are going, oh, panicking, it's red. Remember, there are two things that Mark Twain had a quote about it a long, long time ago. There are lies, there are darn lies, and then there are statistics. Keep in mind, you can manipulate the statistics, and this one is now not accurate in my opinion because we're not doing testing like we were. So there you go. All right, so now I'm going to talk about Supreme Court of the United States because you all had a major decision that came down that you all want to know about. And yes, I know everybody knows what I'm about to say. Arbitration. Yes. Viking River Cruises came out in the middle of June. Nope, this is not the one that you thought I was going to talk about first, but this is the first one chronologically. We're going to go through all of them because, believe it or not, they all have bearing on employment. So even though you may have political comments, please do not engage in political comments in the chat. Let's keep it to the critical questions that have to be done. This does not matter which side of whatever fence you're on. When I get to the more sensitive issues, we have 3 others. There are 4 Supreme Court cases that are critical for you to know about. Typically, these happen at the end of June. They don't typically happen where I'm having to type it at 10 o'clock this morning as it got released, and I'm trying to read a 1,000-page opinion to let you know what it means. Viking River came out in the middle of June. What it means for everybody is, number one, a lot of companies that I deal with have backed off of arbitration because of California. California basically said, well, you can't put people into a class action ban. You can't force them into arbitration. The Supreme Court came out, and I think it's the right decision, came out and said the Federal Arbitration Act supersedes any state law. So if you have an arbitration clause that says that an individual waives, now the PAGA is a Private Attorney General Act. It's a California-based law, but it's the same as what's called a QTOM, which is on behalf of the king, is what it means, but it's basically a private attorney general action across the country. But what they did in California was this arbitration agreement said, you can't sue us anywhere else but arbitration, including your individual claims and class-based claims, POSIT claims, or any other cause of action. And the California court, appellate court, Supreme Court all said, oh yeah, you got to take those into court and you can't bring them here. And the Supreme Court said, not so fast, you can't do that because FAA, Federal Arbitration Act, literally says if an employee knowingly gives up their rights, they're stuck to that arbitration clause. Kentucky had a hiccup on this a little bit ago, about 3 years, and then the legislature cleaned it up. If you're not aware of that, you didn't have a very good attorney helping you because they should have been aware of what's going on with the arbitration and employment agreement that literally was banned for a year while we tried to get it undone. So if the FAA applies and the employee agrees to arbitrate claims, whether they're an individual or not basis, and they knowingly sign it, it shall be honored. It's expected that this is going to create all kinds of legislative efforts, especially in the state of California, so stay tuned and be paying attention to it. If you already have one in place, you need to consider revising it to include your class-based claims, representative action waivers, severability clause, and so on. If you don't have one in place, you need to consider having one in place. I can tell you that having arbitration instead of litigation makes things, it may be a little bit more expensive for the employer, especially in the employment arbitration where you have to pay 100% of the cost. However, it's supposed to be a lot cheaper, a lot quicker, and also, of course, confidential. If it's confidential, then you don't have to worry about people reading about salaries, about your company, about the allegations, and so on. So, in disputed matters covered by the arbitration agreements, if you're already in one, if you're in the early stages of notice regarding one, you need to read this case and understand its impact on you, especially if you have California activities. Finally, remember what I talked about 1 month ago, which is this little beauty down here that I am still seeing companies not include on agreements that I'm being asked to review. The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. This was the act signed into law in, I think, March the 5th. This literally means that everything else you can send. Arbitration regarding sexual abuse or sexual harassment is now not subject to any arbitration. You must go to court. Now, we'll have to see how this plays out. This one down here, sexual harassment, with the FAA, because there are parts of the Federal Arbitration Act and the Sexual Assault and Sexual Harassment Act that don't jive with one another, and that'll be another 6 years down the road. We'll have a Supreme Court decision that says what it is. So now that y'all are like, oh yeah, well, we knew you were going to talk about the arbitration one, let's go to the next one. Again, these are all chronological. So yes, I put at the top the gun and abortion decisions. The gun one came out first. So last Thursday, there was a gun case. New York regulations regarding the ability to have guns in the workplace. I'm sorry, strike that. Guns, conceal and carry. I've had a lot of people say, well, what's the impact now that you're allowed to conceal and carry? Well, first of all, if you're in the state of Kentucky, you are allowed to conceal and carry anyway. Open carry, conceal and carry with or without a license. And so Kentucky, this really didn't have a huge impact on what they ruled. What they ruled was New York was picking and choosing, and it really came down to if you were famous. This was a real example. If you were famous and you applied, and you said, I really need this for my protection because I'm a famous person. They were like, oh yeah, you can get yours. Then the next person comes in and says, well, I need one because I'm really concerned and I'm really afraid. They go, well, no, you're not. Yeah, that's not sufficient. Well, the problem is I've told you all for 54 episodes, golden rule. Everybody gets treated the same. Doesn't matter what your skin color, what your makeup is, what your hair, what your gender, famous, not famous. You can't treat people differently, and that's what New York was doing, so it set it aside. So what is the impact on workplace? Nothing. It has no private employer action impact of this ruling. This ruling is a government cannot engage in additional restriction on a right to conceal and carry. If you meet the regular standard, you can't then scrutinize the individual. However, employers have a duty to protect. We're going to talk about this in a little bit. You have a right to control the workplace environment and the responsibility. And your policies and procedures can, if you decide to, limit or allow. And we're going to talk a little bit when Tyler gets on about whether you should allow. I'll just cut to the chase if anybody can't stay on. Personally, I don't recommend a policy that allows a conceal and carry. I don't care if you allow it, but that person needs to sign a waiver that if something happens, they are responsible, and you do not expect nor condone any action taken. Why? Well, it's the same thing as somebody running out of a store. You don't have your regular store personnel tackle them, accusing them of theft because they don't have the proper training, and you'll get sued if somebody breaks an arm or somebody kills somebody. So we'll get into that in a little bit. Policies, Tyler's going to talk about this a little bit, but those need to cover vehicles, person, conceal and carry, open carry, and premises. Whether you're allowed to have it even on the premises. Actions against employees for a violation, you better have a well-defined policy before you start firing somebody because they have a right to conceal and carry or to open carry unless you tell them to the contrary and post it out and so on. Always consider your liability issues, waivers, agreements, contracts, and other things, because if somebody pulls it out and shoots the wrong person, you're going to be held responsible. So that's the update on the gun legislation, or the gun case. All right, let's talk about the abortion one. And no, we're not talking about how you feel about it. Believe it or not, the abortion case has a tremendous impact on human resources. There were some companies that really jumped the gun, and then when they came out, you kind of had to laugh about it because now they're going to have to back off and go, oh, that's not what we meant. That's not our full policy. Read the fine print. We wrote it in really, really tiny fine print at the bottom. So the reality is this: if you have a health care plan that covers abortion, and believe it or not, most of them do, you're going to have to determine how and whether to provide continued access. The reason for that is you now are governed by different state laws. They weren't really triggering laws. Everybody called them that. Most of them were on the books. They just couldn't be enforced because there was a federal edict from the court, not from a legislature, was never legislated. So the laws were still on the book. They just couldn't be enforced. Now they can be enforced as soon as the federal court mandated limitation was lifted. It went back to the states. It's not a ban. It's not all it said was it has to be controlled by the states, which is where it used to be. It's not a there's no federal law that could be enforced. It had to go back to each state. So the problem for you as HR people, you now have 50 states. You now have certain states that make it a criminal act to assist, aiding or abetting in the ability to obtain an abortion. So the ones that came out and said, we're going to pay for people to go to another state, that would be called aiding and abetting. If you engage in that activity in a state that has made it illegal, you could be found criminally responsible. Your company could be found criminally responsible. Others came out and said, we're going to provide medical travel expenses. Well, again, if you have a state that has a criminal law, that could create a situation where you are aiding and abetting in obtaining what is already deemed to be a crime in a state. So you must make sure you're not doing that. Secondarily, you have issues with ERISA, tax, and other federal laws with regard to giving reimbursement for benefits that may not be in accordance with your then existing policies and procedures and medical care. It could present potential issues with regard to aiding and abetting the changes in the laws of each of the states as the various states are adopting them, so you need to investigate that. And also state laws that are in violation of ERISA could be preempted by ERISA unless, and ERISA is very clear, it cannot be preempted if it is a criminal law. So that's where I was pointing out these state criminal laws. You need to be very careful about allowing this, thinking that it's preempted and you don't have to worry about Kentucky, Florida, Texas, Tennessee, whatever it is. You need to make sure you're complying with each. Like I said up above, many employer plans do cover abortion and they do cover travel for exigent circumstances, extraordinary medical procedures. You need to be very careful if you're going to try to tuck it in there. Federal law generally does not require health plans to cover abortion services. I would highly recommend that you consider not providing them simply because then you are not responsible for medical care and you don't have to deal with the competing states that are the ones that are going to be pro-choice are going to be very, very heavy-handed. The ones that are going to be pro-life are going to be very, 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 very heavy-handed. And the way that I have done some of these things with both holidays and with medical, not with this because this is new, we give $500 for you to use whatever way you want. We give 3 floating holidays for you to pick which ones you want. If you don't want to celebrate the others, you don't have to. So we pick certain ones that are fundamental, and then you pick others, and it's floating, and they can pick whichever one they want. When they run out, they don't have any more holidays. So here's another issue. EEOC has interpreted the Pregnancy Discrimination Act to require health plans to cover abortions in certain cases. Of course, that's when there was a federal edict from the Supreme Court that had no legislative backing for it, that created the paradigm where they could bank on Roe versus Wade and declare that you had to do it. The EEOC, I think, overstepped on that because there was nothing in the PDA to require it. Now, I will tell you, where they are requiring, or where they say that plans must provide it, was in the event of rape, incest, or endangerment of the mother due to other issues. So it's a very rare situation that they believe it fell under the PDA, but we're going to have some legal battles on the PDA now, the EEOC's interpretation of it, because they have banked on something that had no legislative backing. The right to an abortion was never under the PDA or any other legislative act, so they kind of stepped into it there, and we'll have to see what the EEOC does. Health insurers, they are subject to your state insurance laws, which includes laws governing whether policies may or must cover abortion services. So there was a question that was asked in here about how do you design a medical in multiple states. I'd hire a health insurance company and make sure you have a waiver so that they are responsible for making sure that this meshes in all of the different states. This is going to get really, really dicey for a little bit, and you need to get legal counsel, or you need to have someone on staff that understands. And this is really well exceeding regular SHRM as well, because this is cutting edge, brand new, United States Supreme Court, and nobody was I would be willing to bet out of the people on this call, nobody was doing HR 50 years ago when the decision passed on abortion law. So if you were, chances are HR was slightly different back then than it is now. So this is going to be very impactful. Telehealth providers, this creates a substantial issue. Kentucky adopted a policy that said telehealth, the doctors didn't have to ask where you were. They could provide services to you no matter where you were because they were your PCP. That's going to be out the window now because you can't give guidance regarding potential, at least as to abortion care or aftercare, because you can't give guidance to somebody and find out that they're in a state that strictly prohibits any type of activity. So this will change some of the telehealth. It'll change some of your prescriptions that were post-pregnancy assistance prescriptions, abortion pills basically. It will change because you can't get those in the mail in certain locations. There's some big changes there. Employers reimbursing for medical travel. I said to Lyle this morning, I guarantee nobody on here, I'm almost willing to bet, has looked at this outside of me. Yes, this is how I like to spend my weekends and holidays. If you're going to reimburse for medical travel for, let's say, abortion, Google, you better pull out your policy and dust it off and make sure you're allowing the same exact for mental health and addiction. Because under the Mental Health Parity and Addiction Equity Act of 2008, you must provide exact same permission, travel, and so on for any mental health, substance abuse treatment, and other activities. So you might think it's really smart to start adopting this, allowing somebody to go somewhere else for an abortion. Well, now they tell you they can't get substance abuse care here, but they found one in New York or they found one somewhere else, and they want you to pay for it. And you would be on the hook because you have to treat mental health the same as everything else that you're doing. So that's that update. One more, because, hey, let's just go ahead and throw this at Jim at 10 o'clock in the morning on an 11 o'clock webinar. So there was a religious discrimination case that ruled today that will have drastic impact on you, I believe, especially if you're in a public venue, but even in the private. So this morning, if you weren't aware, there was a assistant coach in the state of Washington who was terminated because he was praying privately at the 50-yard line after a game. They tried to tell him, we'll give you a different location. You can do it at the 50-yard line if you wait till everyone's gone. He originally agreed, then he said, no, you know what, I want to pray where I am thanking him for no injuries on the field. I'm going to do it right there on the field where I always have. School fired him, and he took it up, and the Supreme Court has ruled A governmental entity sought to punish an individual for engaging in a brief, quiet, personal religious observance doubly protected. That means, by the way, two different Bill of Rights protected what he was doing. Free exercise and free speech clauses of the First Amendment. And the only meaningful justification the government offered for its reprisal rested on a mistaken view that it had a duty to ferret out and suppress religious observances, even as it allows comparable secular speech, secular being non-religious. The Constitution neither mandates nor tolerates that kind of discrimination. The impact on private employers is not yet fully vetted, of course, because this just happened, and honestly, I still have to read the rest of it because I didn't have time. However, it will impact your policies and procedures, especially those that may try to limit religious observances. You can't treat religious actions differently than secular actions by your employees, even a private setting, because of religious discrimination. And this basically set out that the government had gone way, way, way too far in trying to ban religious, but not doing the same with secular. So there was an allegation that you could make decisions on playing time based upon whether people joined them at the 50-yard line or not. And the Supreme Court said that was pretty much laughable because nobody had ever raised that issue until oral argument in front of the Supreme Court. There was never a child or a parent or the school that alleged that there was any activity where he was trying to determine playing time. Now, they did draw this distinction. If it was part of his job function, if he was giving them plays to play and then praying in the middle of the play, if he was trying to convince them of going out on that field and winning the game, hold on, let's pray before we go, that was different, but this was completely voluntary after the game, without any expectation of involvement or any discipline taken if you didn't get involved. So, public employers, you better dust off those policies, because the ones you have that ban any religion but don't ban others, those are pretty much out the door, because they pointed out that secular activities are not being screened as much as the regular. So that's it. Let me go to Tyler. And I'll introduce Tyler if that's all right, and I'll just let y'all know I broke this up because there was so much with the Supreme Court, I just couldn't handle it all. Tyler's been doing a lot of the policies and procedure work for me with companies, and this was right up his alley. So Tyler is my son. He's a practicing attorney, third generation in my office. We've now opened a satellite office in Eastern Kentucky, and that's where he is. So without further ado, unless you want to do anything, Lyle, I'm trying to speed through this because of all of the things.
Press on.
All right. So Tyler, you're up.
Tyler.
All right. Good morning, afternoon, everyone. Like you said, my name is Tyler Morris. I'm an attorney in Kentucky and in Florida, presently based in Eastern Kentucky. But what we're doing today, we're going to go over some of the liabilities for the actions of your employees and when you are responsible for your employees' actions. So to do that, I think we need to get a general understanding of employer liability for workplace actions. And the liability can really depend on whether an employee's actions were part of their occupation or not. So just some high level examples. Was a employee for your restaurant in the grocery store picking up your groceries. So that's part of their regular course of their job. You could be liable if that employee slips and falls because they are within the regular course of their business. Or even a more far-fetched example, but something that we see as prevalent today, an employee on a Zoom meeting while they're driving. If you happen to know that employee is driving and they run over a person or an animal or anything, you could be liable for that. You knew that they were driving and were allowing them to proceed in the regular course of their business. Something that the courts will look at generally before we really get into some of the workplace violence stuff, when evaluating whether they were within the regular course of their business, courts will tend to look at how you have treated their work. Do you have an employment agreement that spells out their responsibilities? Do you have a policies and procedures or a handbook that defines what they can and cannot do. Those are things that the court is going to look at to determine whether or not maybe you had been negligent in keeping the workplace safe, which, as you've heard multiple times today, is a requirement. Let's go ahead and go on to the next slide. So the businesses that are the most at risk, those are going to be the businesses where your employees are leaving the office, or you are regularly have employees outside the office. Think of, if you have delivery drivers, even for people that work from home now, a lot of the remote workers are going to be more liable for those remote workers in case, in the event that they happen to get injured on the job. Being outside, the injuries are more likely. But to understand liability away from the clock or away from the office, again, you have that regular course of business, and that's when somebody is injured or caused injury during the regular course of their business and within the scope of their duties. That is something that in general, you are going to be liable for as an employer. Then you have what is called a detour. And what really ends up becoming a debate when this ends up going into litigation is whether it is a detour from the regular course of business or whether it is known as a frolic. So a detour you will still be liable for. And that's think of it as when you're driving. A detour, you've taken a brief variation from your traditional job or from your route. But it's still within your job enough that the courts will find you as an employer liable. And generally, one of the reasons that they'll do that is because the employer is going to be more able to pay and to compensate for that loss than the employee. So they are more likely to push towards it being a detour than a frolic so that the injured can be compensated. So what you have with a frolic, and that is when you are not liable. A frolic is when an employee is acting essentially entirely on their own. You tell them to go to the grocery store to pick up those groceries, and instead they go home and have lunch first. Maybe on their way home, they hit somebody. There's a good chance you would not be liable for that. But again, courts are going to try to push for the person that can compensate the injuries to be liable. So it's important to have a good policies and procedures for where they're allowed to go, what they're allowed to do, and really have that enforced, not just stated, because if you're not going to enforce it, then the court is going to look at that history of a lack of enforcement and really hold that against you. We can go on to the next slide, Jim. So this is the big one. This is the one everybody's really curious about. So what about workplace violence? That's the hot topic today. When are you going to be liable? And it's the answer I always hated, and I'm sure you all hate as well. It depends. Courts are going to evaluate everything from your hiring process. Jim, it looks like you threw something up on the screen there. There we go. They're going to look at everything from their hiring process to your handbooks and whether they're in place and whether you enforce them. Like I said earlier, if you're not enforcing your own rules, then they're essentially going to be looked at as invalid. But let's get into some of the things as to some of the events that could create a liability on your end for workplace violence with your employees. I'd say the number one cause there for liability would be a negligent hiring and or retention. So with negligent hiring, did you forget to perform a background check or verify the credentials of an employee, and maybe they had a violent criminal history that you didn't know about, or maybe they have a mental instability that you could have found just with adequate background research? You as a employer have a duty to protect the employees in your workplace, and that includes who else you hire to make a part of that workplace. So you may be liable for an employee's acts of violence if you failed to do the research in hiring. But even to take that further, maybe you didn't do that research. Maybe you forgot, or you didn't have the time or the money or whatever it is. You didn't have the ability to do it then. And that employee became a great employee. They're your highest profit maker. You could be held liable for retaining that employee if you if you later, let's say you found out about their violence and you said, oh, that's my best employee, I really don't want to get rid of them, and they don't do anything like that anymore. Well, let's say they do. You could be liable as an employer for a negligent retention and failing to go ahead and alert the employees to the danger and removing that danger as quickly as possible. And the one that's probably more common here, the one that everybody thinks about, is harassment. And that's every harassment claim, of course, most of you are HR people, you know that has to be taken seriously and truly vetted, and you need to do everything in your power when there is a claim of harassment brought to go ahead and engage your legal counsel with your HR and really evaluate where you should go, because those early steps in a harassment claim can really be critical. So you need to have a proper policy and procedure in place, and you need to follow that policy and procedure, document everything, with every decision you make being supported by the weight of the evidence and really going along with the advice of your counsel, whether it be us or whoever your legal counsel is. When you're drafting these documents and when issues with the documents come up, you really have to work with somebody that knows what they're doing, or it's going to be an uphill battle and a big cost later in your employment. And the final one I have on here is called knew or should have known. And when you're looking at laws, that's kind of the catch-all provision. Maybe they didn't actually do something or didn't do something, but they knew that they should have, or they should have known that they should have. So if your employer knew that they had if you knew you had a violent employee and you had any reason to know that there was a potential for violence, and maybe you looked away again because it's a good employee, or maybe you just straight up didn't do the research, and a really cursory check could have, like a simple background check, really could have let you know that this is probably an individual you really shouldn't have in the workplace. You could be liable there as well. So if you should have known that this person could have brought injury, or maybe you just didn't do anything to really keep your employees safe, you're going to be held liable for that. Workplace violence, harassment, and the retention and hiring, that is all complex, but what's really critical here is it's all very preventable. Your policies and procedures, your contracts, your employment agreements, your handbooks, they can spell out what the court is going to follow as a guideline. Okay, when a court's looking at, okay, you had these policies and procedures, okay, you followed these policies and procedures, you had them drafted by an attorney, and you did everything you could. Well, maybe if something was still wrong, the court's going to say you did all you could. You can't be found liable for that. The first step is really get those documents prepared, have them done right, and then when you have issues that pop up, have them re-reviewed with your HR and your counsel and make sure that they're done correctly, because a harassment litigation is the last thing an employer needs. So finally, I think it's the important part. What can you do to protect your business? And it's the same thing I've kind of reiterated throughout. And that is, you need a handbook, you need your policies and procedures, and you can't let them slide. You can't pick and choose employees that you're going to enforce them against and not enforce them against. If you're going to set these policies and procedures, which you should, they need to be universally enforced. Because if you're not going to enforce them, it's as good as not having them. The court's not going to enforce something against somebody else that you're not enforcing yourself. So that's important to remember. If you're not going to actually do anything about it, the court's not going to do anything about it for you. So I think we put on here, yeah, there it is. Assure widespread distribution of the violence, harassment, and workplace threat policies, and really have a set structure with your HR as to how it's handled, and make sure everything is well documented with that. A complaint comes in, go ahead and have the complaint in writing, launch your investigation, contact your counsel, and really document everything, so that should the disgruntled employee decide to sue you down the road or initiate litigation or settlement, you can at least be fully informed and have the weight of the evidence in your hands and say, that's not what happened, this happened, and we did this, this, and this in response to that. And that's something that when a court's looking at that seeing that you were proactive and preemptive both in drafting the policies and enforcing them, that is going to have a very big impact in litigation. And again, I think to close it out, act quickly. People always hate that, you know, things cost so much, especially nowadays. It's costly to go ahead and draft these documents and to have these preventative measures in place. But I can tell you it's 100 times more costly if you don't, and then you end up getting hit or sued for it. Because the one document drafted is a whole lot different than hundreds of motions and thousands of documents in discovery. We would highly recommend that you get your policies and procedures in place for events like this, and that you have them reviewed regularly. I know we've worked with a few of you on here that you have policies and procedures, but they're 15 years old and they're outdated, and it's probably a good time to go ahead and get in and look at those again. That's all I have for you today, I think, unless there was something else I missed, Jim.
I answered one of them. I answered one. I know this, guys, I know this went long, and I know we lost some because of it, but there was so much to cover. But there is one that was asked, Lyle, and we've talked about it once before, but not direct on point. There was a question about how long after a criminal act can you consider someone for employment, and the answer is you are, as far as the EEOC is concerned, you are not allowed to consider exclusively someone's criminal history in not hiring them. However, I have been very clear with the employers that I represent. Financial crimes, obviously, violence crimes.
Violent crimes and fraud were the big ones, I think, Jim.
Yep. And so the violence crimes are ones that I would use very carefully, document very well, provide the employee with or the candidate with the information under the Fair Debt Collection Practices Act, allow them to challenge it, everything they want to do, but you have an absolute OSHA general duty clause to protect your employees from a potential danger. If you know that someone engaged in extensive acts of violence and you hire them, you could be held responsible. So that is an out, but it's very difficult. The crime, which crime you're going, or which crime they were accused of, when it occurred, whether they've had any subsequent actions, all of that needs to be considered, and that's where your policy needs to be very carefully done to make sure you're not in violation of that EEOC directive about it.
And Jim, if I could add on to that, what he said there, being you need to document it. Make sure you do document everything, because a failure to document is going to be critical down in the end of the road in litigation.
Yep, Belinda, I like your comment. We try to find a win, and we will work very hard. Some of these are no-win situations because you're either violating one law or another. I will tell you that I would highly recommend you focus. Obviously, I don't know your particular circumstances, but I would focus on protection of all employees over a fear of hiring someone and being sued because they were a criminal and you don't know whether their violent history was sufficient that you shouldn't have hired them. I would much rather defend a case well documented about the reason why you couldn't hire somebody who murdered someone 10 years ago but got out on parole, versus having a mass shooting incident and then having to handle the claims of everybody whose family was impacted because you went ahead and hired that person. And I believe that's going to happen soon because of people trying to adhere to the EEOC's obligations on not doing criminal or not precluding people from being hired because of their criminal background. Sooner or later, that's going to catch up, and it's going to be a very sad day when it's a big-time incident that occurs. I'm sure some have already, but just be careful doing these. You just need to make sure that your policies are well done, documented very carefully, and when you make a decision that's close to that line, that you stand by it, but that you are very careful with what steps you took to make sure they all were accurately done. Let me exit out of the screen. Lyle, put it in the, whoops, sorry.
And one quick final thing while Jim's pulling that up, I know he had mentioned that maybe the criminal history shouldn't be the sole reason cited when not hiring someone. Remember, it can be a factor. Don't have it be the only reason. Put it, if you're writing a letter, make sure things are well documented, and don't say that it's the only reason, but maybe there are several factors that led into it.
Right, and always one of those, if it's a financial related crime and they have any possibility of handling finances, always put that on the letter. They will be directly involved in handling financial documents. That's the best way or people's finances, things like that. I know that wasn't the point of the topic today, but all of these things have direct relevance, and with violence being an issue, first of all, I want to say to Lyle, the people that you had on here this time were some of the best in terms of everybody being able to tie together the questions that came together that impacted, whether it was Tyler's group or me with the new Supreme Court, the questions sent to Jason, answered by Lisa, or vice versa, were directly on point. Congratulations on a well-run, very put together in terms of people talking to each other about these issues that are so interrelated. You
bet. Well, it's all timely, boy. It's all coming at us like rapid fire. So, hey, Valinda Taylor, I didn't see you, but I love having your questions. I really appreciate it. You're always on top of stuff. That's great. And anything final? Because I've got one other person to introduce today.
Yeah, there is some. Stacy asked, will we be able to access the recording? Yes, these recordings are put on both the Hannah Resource Group and Morris & Morris websites. You can go to either one, click on it. The recordings are always available. All the way back to the very first one we ever did, Lyle, right?
Oh yeah, and we usually send a link out to it right after, a little bit after the call. As soon as we get it, we edit just a little the front and back end of it or something. And
yeah, that'll probably be tomorrow. We'll send the follow-up email with the link and all of the resources that were listed today.
Thank you all for hanging with us so long. I think we will have more stuff, and we may come back. We're not going to come next Monday because we hope you'll all be off on vacation. But on Tuesday, we're talking about having one, and we'll let you know in plenty of time. You know what? Just for fun, I want to introduce a new employee that joined us, and that's Candace Hall. You can see her photo on there. Candace, she is our new Director of Talent Acquisition, and boy, has she stepped into a big job. We have employees in Lexington, of course, but also in Frankfort and Louisville, and in Indiana, New Jersey, and Maine. So our business continues to grow, and we're having a good time doing it, and we're just delighted to have Candace. She has a terrific background and a lot of experience, and she's going to be fun to have on the team. So Candace, welcome. All right, anything else? Jason, thanks for hanging in here with us. Nice job. We'd like to stay in touch.
Yes, sir. Thank you for having me. It's been
anybody want to, you can open your camera if you want to speak up and say something. Now's the time. Five, four, three, two. Everybody have a great week.
Thanks, everybody.
Fun to see everybody. You take care.
Thank you, guys.